have joining us on the program this morning. Just had a great conversation with Will Flanders from Wisconsin Institute for Law and Liberty, and they have such a great team over at Wisconsin Institute for Law and Liberty. I've invited attorney Cory Brewer to join me on the show this morning. Good morning, Cory. How are you?
Good morning. I'm doing well, thank you.
So we had a couple of I guess we chatted once this week about, I think the Title IX rule changes by the Biden-Harris administration are in the news, and there are a lot of concerns, rightfully so, by parents. We've seen some problems in other school districts throughout the state. I'm thinking of the Argyle School District as an example. They did not renew the contract of a teacher that had refused to use the preferred pronouns of a transgender student. And then I'm also thinking about the Sun Prairie School District and how there were girls that were exposed to a biological male in their locker room, and they were, as I recall, and you can correct me on this, they were forced to shower in front of or undress in front of a biological male in the Sun Prairie School District. And I think that there was another example in Eau Claire, and I think that there's yet another example in, now I can't remember the school district, but of a parent who actually removed her daughter from a school district. But we're seeing this all over the state. We're seeing this all over the country. And I would like, first of all, I know that you're representing you filed an amicus brief in federal court to protect girls. Let's start by talking about that, and then we can kind of branch out to what's going on here locally and then throughout the state.
Yes, thank you. So these new Title IX regulations under the Biden-Harris administration, they were finalized this past spring in April, and the effective date was August 1st. Over the summer, there were a lot of lawsuits against the rule. Every one of them so far has won, and in every single one of those, the court has entered what's called a preliminary injunction enjoining the rule, which means basically it's on pause, but only as to the parties in those cases. Or there's one in Kansas that's a little bit broader, involving schools where Moms for Liberty have children. So the federal government, if they're subject to an injunction, they cannot implement or enforce the rule in those cases. But because it's a preliminary injunction, which kind of means it's on pause while the case continues to be litigated, many of these cases have been appealed. The government has filed an appeal. So now that those initial decisions are being challenged, we have an opportunity to weigh in as not a party to the lawsuit, but as an interested party with regard to the issue. So our client in Sun Prairie, as you mentioned, they were, she and three other freshman girls at the time were rinsing off after a gym unit. It was a swim unit in Phi Ed class. They went into the girls' locker room. They still had their swimsuits on, and they were rinsing off. And this is the longer story. We tell the whole thing in our brief that we submitted with the court. But essentially, a transgender student who was an adult male, he didn't surgically or medically transition, so he had the anatomy of a male, fully undressed and showered right next to them in their shower. And we are representing her. She's a junior now, and she wants to use her story to show these courts, hey, this is what I experienced, and if this new rule is allowed to go into effect across the country, this is going to be not just common, but actually required, that schools allow students to choose their locker rooms, bathrooms, etc., any facility based on gender identity.
Okay, so I guess the encouraging part of what you just said is that any challenges to these rule changes have been successful. I mean, it's really hard for me to, I don't know, process the fact that we have to defend the private spaces of our girls in the and frankly, I've even heard from parents of boys who are concerned that there might be a problem if a and I get confused, but a biological female that believes she is a male uses male spaces. If and these parents have expressed concerns about the a possibility of some sort of allegation against their sons as it results as it pertains to a biological female using male spaces. And so I mean this really does affect um, uh, children across the board, whether you're a male or a female. And so I guess what I'm wondering is how do we how do we get a handle on it, and how do we ensure that the spaces that are provided to kids in their in their schools are well the I guess biological males and biological females, how can we be assured that they will be protected in with regard to these Title IX rule changes?
Yeah, that it's difficult right now because the litigation is still ongoing. But I do agree with you that there's a reason to be hopeful because these court decisions so far have been successful, and we have some really strong decisions from several of these courts. Probably a lot of your listeners know that Title IX was passed back in 1972 to prohibit sex discrimination in educational activities. This was very clear at the time that it meant male and female, and that it was intended to give girls equal opportunities, safety in their private facilities, which included protection from sexual harassment, etc. Now that the Biden administration has adopted a new regulation, which they can do, they can go through this rulemaking process through the Department of Education to change the way Title IX will be implemented. But what they did was they did a lot of things, but probably the most significant piece of it was adding gender identity to the discrimination definition. And courts so far have recognized that effectively it turns Title IX on its head, because instead of protecting girls in their private spaces with regard to their opportunities and their educational activities, it actually requires schools to allow transgender students to use whatever bathroom, locker room they identify with. It totally redefines the definition of what is a hostile environment. So prior to this new rule, there was a very, very specific definition of what's a hostile environment and what is sexual harassment. And it required a pervasive, severe, and objectively offensive event to take place. That's kind of paraphrasing what it was, but it had to be pervasive, severe, and objectively offensive. Now it can be subjectively or objectively offensive. So take our case in Sun Prairie as an example. If the transgender student wanted to use the girls' locker rooms and he wanted to shower in the girls' locker room and he felt uncomfortable or unwelcome, or if the girls were to speak up and say, hey, I'm uncomfortable with you in the girls' locker room, it could actually be, under this new rule, the girls could actually be considered the harassers in that scenario. So that's like a perfect example to show just how egregious these new rules are.
Okay, my head just exploded. I guess what's so frustrating is that these rule changes are at the peril of the overwhelming majority of students in the United States. So, and let's just take girls as an example. They are being asked to sacrifice their own safety, their own peace of mind, their own privacy in favor of those who, and I'm just going to say it like it is. This is a form of a mental disorder that these transgender people have. And so, as opposed to addressing the mental disorder that these people have, we are being asked to accept it. We are being asked to enable this mental disorder to continue. And I guess it's so frustrating. I did share with you, I had a conversation with the superintendent of the DC Everest public schools, just yesterday, and we talked all about this particular issue. And I asked him several pointed questions. He kept referring to the Whitaker case and the policy that has been adopted by the school board in the DC Everest School District. As I understand it, Policy 2264 is not Title IX related, and that these are, and I'm paraphrasing now, these were his words. It has to do with the enforcement of the decision made in the Whitaker case from 2017.
Yeah, I think, to your first point, and I think a lot of administrators and school board members recognize this, and Will has written about this and hired experts to discuss it as well, but gender dysphoria is real. We recognize that. But on the one hand, you have the medical establishment and psychological establishment that seems to be pushing this model of affirmative care. So rather than trying to see if there's any underlying issue that perhaps a child could be treated for or helped with, the model is affirm. If this girl thinks she's a boy, use her male name and pronouns immediately. And a lot of times, and we were talking about this off air, a lot of times that involves keeping a secret from her parents, which, again, we think that's illegal. We think it's unconstitutional. It violates parents' rights. But this new Title IX rule under the Biden-Harris administration, it doesn't define gender identity. It doesn't have a standard. It doesn't require a diagnosis of gender dysphoria in order for individuals to be able to use the separate sex facility. It's just vague. And I think they do that on purpose, because if a student says that they're the opposite sex, that they're the opposite gender, that's all it takes under the language of this new rule. So that's kind of the first thing that I wanted to point out. And you mentioned as well the Whitaker case. And Will will be hosting a webinar on Monday to dive into this in a little bit greater detail. But yes, there was a case in 2017 brought by a transgender student against the Kenosha School District. It was under the old Title IX rule, obviously, and the student's argument was that it was sex discrimination against that student to not let, it was a girl transitioning to a boy in that case, to not let her use the bathroom that she associated with rather than the bathroom associated with her sex. And there's some disagreement about exactly what that case means in terms of the procedural posture. There are other cases that have attempted to distinguish it. Those have been unsuccessful so far. But what it has come to be interpreted as meaning is that schools that want to separate bathrooms, and this is really key, that case was about bathroom use. It didn't go beyond that to locker rooms or anything else. It was about bathroom use. Essentially, schools that wanted to separate bathrooms by sex, if they got sued, they'd be likely to lose, because the court kind of said that, hey, it likely does violate Title IX to require a student to use the bathroom that aligns with their biological sex. And even in that instance, there's courts in other part of the country that have come down completely the opposite way. So a lot of this is going to require the United States Supreme Court to eventually weigh in.
So, and as I understand it, and I had a lengthy conversation with the superintendent of DC Everest School District yesterday. As I understand it, the policy that has been implemented by the school board, this policy 2264, does not talk about the sports or the private spaces other than the restrooms in which they have in the DC Everest School District gender neutral options. And I mean, I asked very specific questions. Will any student or teacher be disciplined for refusing to use preferred pronouns? I mean, his response essentially was, we don't anticipate that will be happening. I mean, there was a lot of I know that he was being very careful about what he said, and probably under the advice of an attorney, but I guess my impression from that conversation with him is this is well, I mean, I frankly, I don't think it has to be that complicated, because in my opinion, it's sort of black and white. It's very common sense. And what's the way that we have done it for as long as schools have been? Well, let's just go back to the times of Laura Ingalls. I'm pretty sure they had a boys' bathroom and a girls' bathroom. But anyway, I guess what I think is most frustrating for parents, for taxpayers, for those of us who are watching this issue play out is that it's constantly changing, and because of the courts that are now involved. And I guess you just cited that at some point the United States Supreme Court is going to have to weigh in on this. As of today, the Title IX rule changes of the Biden-Harris administration, are they in effect or not?
The short answer to that is yes, they are in effect, but with a caveat, and this is an important caveat, is that if you're subject to an injunction, the federal government cannot enforce them or implement them or force you to implement them. So those would be states that are involved with the litigation, or if you're a Moms for Liberty member and you've added your child's school to a list with a district court, that results in that school being included in the preliminary injunction. But if you're not subject to an injunction, then yes, they went into effect on August 1st, and they do have the force of law. But I will mention that implementing a policy that conforms to the new rule, it doesn't mean you're 100% free of risk of liability. We have a resource on our website about this as well. I think a lot of boards are being pressured to implement these, and they're being scared into thinking, oh, maybe we'll lose our federal funding, or we'll get sued, or worst case scenario will happen. And while yes, that is a possibility, there's also a possibility of a lawsuit coming from a parent association or a young girl, the other side, for saying that, hey, actually you're violating my rights and my civil rights for taking away my opportunities, my privacy, my safety, etc. And just to turn into your first point, we actually did also include in our brief, and this seems very basic, but we have a whole section about how bathrooms and locker rooms have always been separated by sex to protect safety and privacy, especially for young girls. And there's actually case law to support that as well.
Well, and I mean, I'll just even say I remember the very uncomfortable time when I was in junior high, in which we had a swimming class, and this was just, I mean, obviously we had a girls' locker room and a boys' locker room, and we were issued, just perish the thought of a swimsuit that was, property of the school district, and then, we had to change into them and change out of them and shower, and I mean, that in and of itself is an awkward situation for many girls, but to compound that by the possibility of a biological male being in that space as well is just, I do not understand how those that are embracing this, and those that are the Biden-Harris administration that is enforcing this, that they are not putting themselves into the shoes of those. Well, although of course I wasn't wearing shoes in the girls' locker room with a swimsuit on, but to actually put look at the perspective of the overwhelming majority of children that are not suffering from some sort of mental disorder known as gender dysphoria, and it's really, I guess, to and I'm having difficulty putting this into words, but to favor the very slim, tiny minority of people that are affected by this, and to essentially punish the overwhelming majority of those that are not. It seems to me that they hold all the cards at this point, and I think that's what is most maddening and frustrating for so many of us.
Yeah, you're exactly right. And a lot of people know Riley James, swimmer, who has spoken out very prominently and effectively to defend girls on these types of topics. Another individual who has spoken out is Paula Scanlon,
Mm-hmm.
and she's pretty well known, but not as much as Riley. And Paula was actually on the team of Leah Thomas or Will Thomas and had to share a locker room daily for swim practice. She went through it. She experienced it, not just having to be have the unwelcome exposure of a male undressing in her private space, but having to herself get ready for swim practice in front of a male. And she speaks very articulately about that. But you're exactly right, because under this new rule, if a girl feels uncomfortable doing that, guess who has to leave? The girl. And it's totally backwards. This is just an anecdotal example, but I've actually heard of girls where the majority of them will go use the gender neutral bathroom because they don't want to change in front of a male. And the gender neutral bathrooms don't have the capacity like a regular locker room would. So even beyond their rights and their privacy being violated, logistically, I mean, this won't work. There are even districts talking about, well, what would the cost be if we actually changed our facilities to be able to accommodate? They're well-meaning. They want to protect girls. They want to comply with the rule. They don't want to violate the law. But we think this is unlawful, and we're hopeful that ultimately the challenges in court will be successful, and this new rule will be gone. But it'll be a while.
Right. Well, and so patience is a virtue in which I have very little, unfortunately. So, Cory, I did post on WSAU's website on my blog all the information about the upcoming webinar, which is this coming Monday, 11 o'clock, right after Meg Ellefson show ends. And you can sign up for it. The links are on our website. They're obviously, all the information is also available on your website as well. But just for ease of our listeners, you can go out to WSAU.com and click on the blog, and it's just entitled What Wisconsin Parents Should Know About Title IX and School Policies. And you can sign up. The links are there, or you can go out to will-law.org and do the same thing. Anything else? Just in summary, we're a little bit over, but I wanted to give you kind of the final word, Cory.
I will just add that the Monday webinar is a joint webinar with Southeastern Legal Foundation, and they're representing Moms for Liberty in the ongoing litigation, so you'll have access to their perspective as well. And then if you're working, if for whatever reason you can't make it at 11, please, if you're interested, sign up anyways, because we always record these, we make them available, and if you're registered, you'll get the email right away to be able to watch this when you do have time.
All right, Cory Brewer, thanks for joining me this morning from Wisconsin Institute for Law and Liberty. Keep up the great work. I know this will be an ongoing conversation, and would love to have you back for updates as needed.
Thank you very much.
Have a great weekend.
You too.
Thanks. Going to the 8:30-ish news.